Good morning, everyone. Today is Monday, April 27th. We're almost to the end of this month already. I can't believe it. Jeez. Before you know it, we're going to be at Christmas. Today, I wanted to finish up on going through the Pennsylvania versus Nicole Virzi. She is the young graduate student from SDSU who is charged with the murder of a newborn baby of her best friend who was in her care while the parents were taking the twin to the emergency room for an injury to his genitals, which I'm I believe happened while that baby was under this Nicole's care also. So there's a lot to finish reading in the motion. She wanted to suppress a statement that was made in her interrogation, and we are going to finish reading the motion on that and the decision. So let's get to it. So, I hope everybody had a good weekend. I was hoping for sun and good weather because that's what I was experiencing on Thursday and Friday. To my surprise, it was cold and windy and rainy, and now that it's Monday, it's sunny and warm again. So, isn't that just always the case? Um, my name is Wendy. This is Truly Sinister. Welcome. Don't forget to like and subscribe. I'm somewhat new to YouTube, trying to build my channel, and any support or new subscribers is very much appreciated. I'm still working my way through some kinks and whatnot, but I'm doing this all on my own. I don't have really anybody to pick their brains, so to speak. So, yeah, what you see is what you get. Sometimes I'm a little harsh. I can use bad words a lot. But I do tell stories that speak to me and that I feel strongly about, and you will always get my honest opinion. I will never be biased. I will try not to be biased anyway, but I'm biased enough. I will pick a side. I don't ever believe that there's a middle ground unless you're Switzerland. Um, Sorry about that. Decided to use Wi Fi today instead of the Ethernet cable, and I might be kicking myself for that. But anyway, I've never met anybody that didn't uh, believe more in one side more than the other ever. I mean, you may not 100% agree with the one side, but everybody leans to one side or the other. And if they tell you they don't, they're probably not telling you the truth. Um, I will always give you my honest opinion and why I feel that way. And you probably won't, a lot of you probably won't agree with me, but at least I'm being honest. And like Melanie Little says, I don't sit on the fence because the fence gives you splinters. So I pick a side. I feel like it's more exciting that way. I feel like and I will give you, I will give you information equally on both sides, but I will not hold my opinion back, and you will always know what side I'm leaning on. And I don't have a problem with people picking the opposite side of me. And if you want to debate it or try to convince me to hop the fence and come to your side, I invite it. I think it's healthy to have back and forth as long as you don't get ugly and take it to the mud. I think it's healthy to disagree. I mean, right? I think it's healthy to question the government. I think it's healthy to question law enforcement, make sure that they are staying on the up and up. I feel like we don't do that enough. We've put too much trust in them, and we've become lazy as a community, as a society. And look where it got in Massachusetts. So there's that. I mean, that's what, let me see, sorry about this. That's what being content will do. You tend to quit asking questions. You tend to take everything at face value, and then you get in these situations that Massachusetts is in where they can't trust they can't trust their government, they can't trust their DAs, they can't, I'm not saying all of them, but they can't trust just one second. Is that better? Except now you can't see my background, but whatever, we'll fix it later. We don't need to do it live. But yeah, I mean, you need to keep your politicians, your justice system, you need to keep them in check. And the only way you can do that is to ask questions. And if they have a problem answering your questions, then you know that there's an issue. So I just welcome everybody, and I hope that I'm what I and I do take suggestions. I mean, I'd rather do stories that people are interested in than not. So, I mean, and you don't have to agree with me. We could do something that I haven't even, this you bring them to my attention. So I can only cover, I mean, I can only go through so many news stories on my own. So I do need help coming up with different cases and stories to cover. I lean towards the unjust ones, but I will cover anything. I mean, if it interests you, it interests me. So there's that. Um, yeah. So, have you ever had a day where you felt like you were so productive, and then you sat down at the end of the day and you made a list of everything you got done, and you realized that you weren't productive at all? You got shit done. That's how it was this weekend for me. I just, yeah. So I have a lot of stuff to do today. So I wanted to get on here this morning while my husband's at physical therapy. Um, sorry. Um, but I look like had a stroke. And so I'm trying to figure out why my mouth is lopsided. And it's terrible to see yourself on screen because you pick yourself apart, and that's not good. So anyway, yeah, my husband's in physical therapy. My nephew is at school, and so I actually have time to do it now. I put my workout off and the dog walk off, all for you. So anyway, um, let's talk about Nicole Virzi. This young lady, this happened in 2024, I believe. Um, this young lady is a grad student, or I'm sorry, she's getting her PhD at SDSU. And she went to Pennsylvania to visit her friend, and she, according to her, ended up being treated like a nanny, and she was very bitter about that. She was visiting a good friend of hers who had twins. I believe they were 6 weeks old, twin boys, and it's just a terrible story. But she was visiting a friend who had just had twin boys 6 weeks ago. She felt bitter because she felt like she was being treated like a nanny and not a guest, I guess you can say. And long story short, she was asked to watch this newborn while the parents took the. She was asked to watch Leon Katz while the parents took his twin brother. What's his? I can't remember his brother's name. Aiden, is it? Let me see if I can find it. Oh, God. I should have been better prepared. Sorry. You know what keeps coming to my mind is the name Olin from, the Alexander brothers. Leon's twin brother. What is his name? Keeps telling me Leon's name, but it's not telling me the brother's name. Anyway, they took his twin brother to the emergency room for an injury to his genital area. And this injury apparently other baby to the ER. In what world is that a smart decision? Maybe they didn't suspect her, but they do make a point of saying that this injury occurred while the baby was in Nicole's care. So it must have crossed their mind, right? For it to come up. So I'm not sure what they were thinking, if they were thinking, or maybe they didn't suspect it. Maybe it came up afterwards. I don't know. But baby 6 weeks old is not going to injure his own genitals. I'm sorry. I mean, I don't care what he did. I don't care if he grabbed him and pinched him. A 6-week-old baby just does not have the strength to cause an injury to himself like that. I mean, in reality, come on, let's be real, right? So there's that. So let's read this article to bring you up to date on who Nicole Virzi is, and then we'll move on with the motion papers. And I'm going to be wearing my glasses, so I'm going to hide my face because I don't like how I look at my glasses. Sorry about that, but it is what it is. Okay. Woman who was angry her friend made her do nanny work, quote unquote, while visiting and killed one of her newborn twins loses big in court. Okay, this was just this last month, or 2 months ago, February 24th, 2026, okay? And this is Nicole Virzi. Before her arrest, after her arrest. A Pennsylvania judge refused to suppress statements made by a 31-year-old PhD student in which she allegedly admitted to inflicting fatal injuries on one of her best friend's newborn twins while babysitting. Allegheny, is that how you say that? Allegheny County Common Pleas Judge Jill E. Rangos on Monday rejected defendant Nicole Virzi's request to preclude jurors from hearing her tell investigators that she intentionally shook and dropped the infant multiple times in 2024 until she heard a quote-unquote crack. Oh my God. 6 weeks old. Virzi is charged with criminal homicide in the death of 6-week-old Leon Katz, whom Virzi allegedly killed while babysitting as his parents were at the hospital with his twin brother. She is also facing multiple counts of aggravated assault and endangering the welfare of children, including allegations that she was responsible for injuring Leon's twin brother. Prosecutors have already said they will seek the death penalty. Wow. Virzi's defense attorneys in November asserted that her potentially inculpatory statements to police, including alleged admissions to intentionally injuring Leon and having an uncontrollable compulsion to quote-unquote hurt kids, had been unconstitutionally coerced by detectives after she spent more than 12 hours at the station under extreme circumstances, the Pittsburgh Tribune reported. Whoops, sorry. Rangos reportedly reasoned that while in custody, Virzi met with a defense attorney for nearly an hour and spoke with her parents before making the alleged statements. Quote, the vast majority of time she was in that room, she did not appear to be in, end quote, the judge said, adding that Virzi's comments appeared to be, quote unquote, knowingly, intelligently, and voluntarily made. Background, Virzi, who was living in San Diego, traveled to Pennsylvania in June 2024 to see Leon's mother, who was her best friend, according to the Tribune Review. As Law and Crime previously reported, this is from Law and Crime's page, this article. On June 15, 2024, Leon's parents asked Virzi to babysit the newborn while they took his twin brother to the hospital for injuries authorities now say were inflicted by Virzi. Just before midnight on June 15, Virzi allegedly called 911 to say that Leon Katz fell from a bassinet and hit his head. This is a 6-week-old baby, mind you, okay? Several hours later, on Father's Day, doctors pronounced the baby dead at a hospital. On Father's Day. Think about that. How heart-wrenching is that? Investigators said they learned that Virzi was the only one taking care of Leon at the time, since the victim's parents had taken the other son, Leon's twin brother, to the hospital after Virzi, quote-unquote, discovered an injury to his genital area. So it was Virzi who discovered the injury. That's a little telling, isn't it? A doctor who examined the injuries of both twins determined that they were, quote unquote, consistent with having been sustained as a result of child abuse, as these are inflicted injuries that are not natural and not accidental. Court documents said, noting that all of Leon's injuries were acute. After Virzi allegedly agreed to speak with the detectives and was read her Miranda rights, she was, quote, unable to provide any plausible explanation for the cause consistent with the extent of the injuries that Leon Katz sustained while in her care, end quote. The affidavit continued. According to her version of events, Virzi, quote, fell asleep for a period of time while Leon was in the bouncer seat, end quote. Woke up, saw that the baby was not strapped into the seat, and got a bottle for him from the kitchen. So while she's taking a nap, he was not strapped into the seat and he stayed in the seat. But after she woke up from the nap, he falls out. I'm not buying it. But, you know, she's innocent until proven guilty. That's how our justice system works. So we need to hear all the facts. I mean, maybe she has an explanation. While in the kitchen, she heard screams, picked the baby up off the floor, saw a bump on his head, called Leon's parents, and then called 911. The documents described her account. After detectives repeatedly confronted Virzi over the fact that her explanation didn't match up with the severity of Leon's injuries, since he would have only fallen 18 inches from a bouncer, she allegedly confessed to intentionally harming Leon. Quote, I'm going to tell you the truth. The biggest part of that truth is that I did not want him to die, end quote. She reportedly told the detectives. Quote, from a very, very young age, I don't know what it is, but I always had this urge, almost like a compulsion I can't control, to hurt kids, end quote. That's scary. And she's going to she's going to school to get her PhD in clinical or psychology. I'm not sure which kind of psychology, but it's psychology. She said she, quote, kind of grew angry, end quote, after coming to Pennsylvania to see her best friend and then, quote, being put to nanny work, end quote. What do you think was going to happen? She just had twins that are 6 weeks old. She's a new mother. She wants her best friend there. What do you think she wants you there for? She needs help. She's overwhelmed. She probably has a touch of postpartum. I'm sure the father went back to work. Somebody has to work and provide for the twins. So what do you think you were going there for? To go out and party? Go to the bars? Hang out? You're adults now. What do you think you do? Quote, something about that built up a lot of anger in me, end quote, she said. So when I was alone with Leon, I shook him a couple times, hard, and I dropped him a couple times, hard. She additionally admitted to flipping Leon upside down and onto the tile floor in the bathroom, stating that afterward, quote, oh my God, this makes me almost physically nauseous. I can just picture it in my head, and I have a terrible I have a terrible habit of doing that. I guess it's my empath. I'm a big empath, and it's like I can just visualize everything that people tell me, and it's very stressful. Sometimes it gives me anxiety. A since deactivated online profile for Virzi's doctoral pursuit said that her research at San Diego State University focused on, quote, the complex interplay between psychological factors such as depression, stress, negative affect, and trauma, and critical health outcomes and behaviors such as metabolic syndrome, heart disease, obesity, eating behavior, and exercise, end quote. Quote, I am particularly interested in exploring these relationships within female and trauma-exposed populations, end quote, the bio said. By concentrating on these relationships, my research aims to shed light on the unique challenges and opportunities for intervention within these vulnerable groups. Virzi's trial is scheduled to begin October 1. So that is the background. That's how we got to where we are. And her trial was actually supposed to take place, I believe, last year, and it got pushed back. And then they filed this motion to keep her statements from her interrogation from the jury. And that's what we're going to finish reading today. And I hope I can remember what page we were on. I have a feeling I can't, and it's going to piss me off. Um, sorry. I have it saved, but I have it saved on a different browser and it won't let me share it on this browser. Go figure. It's so frustrating. Like I said, I'm new. I'm still learning. Mm. Mm. Okay, now I'm having. This is going to piss me off. What else is new, right? Mm. Okay, I found it. I'm just looking for the place we were at. I think we had just finished a footnote, if I remember correctly. Okay, we'll just pick up um, here. I think I might have read this um, paragraph already, but we'll just start there to like give it a little recap. Okay. As a final matter, because Ms. Virzi's statements were obtained in violation of her constitutional rights, those statements must be excluded along with the fruits of all the subsequent search warrants obtained in reliance on them. The exclusionary remedy for illegal searches and seizures extends not only to the direct product of the illegality, the primary evidence, but also to the indirect product of the search or seizure, the secondary or derivative evidence. Here, the evidence obtained from any search warrants must also be excluded on the ground that those warrants were tainted by the illegally obtained statements. Roman numeral 3, Article protect defendants like Ms. Virzi from investigators' lies. Yeah, I don't think it's fair that detectives can lie to you to get you to compel you to say something. Because what if you're just saying it because of their lie? What if you really didn't do what they're accusing you of, but you're afraid of what they're lying to you about? So, you want to trust them, right? We want to trust our police force. So you say what they expect you to say. I mean, why are they able to lie to get you to say something? I mean, to me, that's not an honest statement then. 41. Even if Ms. Virzi's federal constitutional rights were not violated by the manipulative and coercive interrogation, this court should find that Article 1, Section 9 of the Pennsylvania Constitution provides greater protection than the Fifth Amendment protection against self-incrimination by forbidding the police from lying about the nature of their interaction with a potential suspect, as investigators did here. And then it cites a case, Commonwealth v. Foster, acknowledging that, quote unquote, this issue appears worth of our review in a case where the argument has been preserved. Also Commonwealth versus Edmonds, it is both important and necessary that the Pennsylvania Supreme Court undertake an independent analysis of the Pennsylvania Constitution each time a provision of the fundamental document is implicated. 42. The Pennsylvania Supreme Court has not shied away from rendering its quote-unquote independent judgment as a matter of distinct and enforceable Pennsylvania constitutional law, and in doing so recognizes it is not bound by the decisions of the U.S. Supreme Court on similar constitutional provisions, but instead may consider the opinions for their persuasive value, so long as the Pennsylvania Constitution provides the minimum levels of protection which the analogous federal constitutional provision provides. Just one second. "43. Due to the significant importance the Pennsylvania Constitution places on individual rights and criminal procedure, our Supreme Court has held that defendants may seek greater protection under the Pennsylvania Constitution and has identified certain factors that should be briefed and analyzed by litigants in each case. Relative to the specific provision, Foster 332A 3D at 895. The factors are as follows. 1. Text of the Pennsylvania constitutional provision. 2. History of the provision, including Pennsylvania cases. 3. Related cases from other states. 4. Policy considerations, including unique issues of state and local concern, and applicability within modern Pennsylvania jurisprudence. Here, all these factors weigh in favor of finding that suspects enjoy increased protection from investigators' use of falsehoods under Article 1, Section 9. I wish all states had that article. 44. First, the text of Article 1, Section 9 provides, quote, in all criminal prosecutions, the accused cannot be compelled to give evidence against himself, end quote. Emphasis added. The Fifth Amendment, by contrast, provides only that, quote, no person shall be compelled in any criminal case to be a witness against himself, end quote. Emphasis added. On its face, Article 1, Section 9's protection against giving, quote-unquote, evidence is broader than that of the Fifth Amendment, which applies only to being a, quote-unquote, witness. This factor thus weighs in favor of finding broader protections under Article 1, Section 9. Number 45. Second, as for the history and case law surrounding Article 1, Section 9, the Pennsylvania Supreme Court has acknowledged that, quote, the primacy of the Declaration of Rights to Pennsylvania's charter requires stronger protection of our liberties than under the federal counterpart, end quote. In fact, Article 1, Section 9 was codified 15 years before the Fifth Amendment and subsequently served as a model for the federal provision. Importantly, Pennsylvania's inviolate, end quote. The Pennsylvania Constitution further affirms that citizens have, quote, certain inherent and indefeasible rights, end quote. These rights were ensconced in the original draft of the Pennsylvania Constitution, long before the Federal Bill of Rights, which was added 3 years after the U.S. Constitution was ratified. I want to look at that word, ensconced. I'm not too proud to say I don't know what that means. So just one second. Ensconced means to be settled securely, comfortably, or snugly in a place, or to be hidden, sheltered, often implying a reluctance to move. It is commonly used to describe someone getting comfortable in a chair, a hidden object, or secure established position, such as she was ensconced in the armchair. Okay. Back to it. Number 46. While the PA Pennsylvania Supreme Court has at times taken inconsistent stances on whether Article 1, Section 9 provides broader protections regarding the right against self-incrimination than its federal counterpart. Quote, on several occasions, the court has specifically concluded that the protections of Section 9 exceed those in its federal counterpart, end quote. Interpreting Article 1, Section 9 to afford greater protection than the Fifth Amendment. Commonwealth versus Swinehart, finding that Article 1, Section 9 is more expansive than the Fifth Amendment. Then the Commonwealth versus Turner, holding Article 1, Section 9 provides greater protection than the Fifth Amendment. These decisions underscore the centrality of Article 1, Section 9 to the panoply of rights enjoyed by Pennsylvania citizens, and how those rights are interpreted more broadly under the Pennsylvania Constitution. Indeed, in a decision from just this year, the Supreme Court acknowledged that the issue of whether Article 1, Section 9 provides greater protection in this area and, quote, prescribes police from lying about the nature of their interaction with a potential suspect, end quote, is one that, quote, appears worthy of the Supreme Court's review, end quote, in a case where it has been properly preserved. Such a strong endorsement is worthy of this court's consideration here. 47. Third, courts in other jurisdictions have acknowledged the dire constitutional consequences of allowing investigators to misrepresent the truth when confronting a suspect. See State v. Baker. Opining that misrepresentations about the existence of incontrovertible physical evidence that directly implicates the accused is an exceptionally coercive interrogation tactic, and its use is a strong indicator that the suspect's statement was involuntary. In certain cases, lies about incontrovertible physical evidence may, standing alone, render the accused's subsequent confession involuntary, end quote. And I agree. I think if you have to lie to get them to confess, then it's probably not a 100% true confession. I totally agree. And I realize that criminals lie. I mean, that's, no criminal I've ever seen admits their crime. But that's a far cry from making a confession to a crime that they may not have committed. You see what I'm saying? So, and I think that the fact that police detectives can lie about physical evidence that they hold, placing the suspect there or placing, the weapon or whatever in the hand of the suspect, whether it's DNA found on the victim or DNA found at the scene or fingerprints or whatever, I don't think they should be able to lie about that. I feel like that is not, you're not fighting fair at this point. And defendants are guaranteed a fair trial. And I realize these aren't defendants yet. They're suspects, but you're trying to make them a defendant. So why can you fight dirty and unfair up until the point where they become a defendant? And then once they become a defendant, then you can no longer out of both sides of your mouth. And it just doesn't make sense. So it should be fair all across the board. From the minute you are deemed a suspect, it should be fair, fighting fair. Holding that the minimization method of interrogation, i.e. repeatedly describing the crime as understandable or justifiable, is a form of misrepresentation that creates an implied incentive for the suspect to confess in exchange for more lenient treatment. Promises of leniency necessarily imply the threat of harsher punishment, which can lead to involuntary confessions. Suspects' inculpatory statements were involuntary where police officers deliberately lied to a suspect about the purpose of the interrogation. 48. Yeah, they took her under the guise of they just wanted a statement. They didn't say that she was a suspect. 48. Even the U.S. Supreme Court has recognized that such misrepresentations are problematic under the Fifth Amendment.
Recognizing that misrepresentations made by police to suspects during an interrogation are relevant to the issue of voluntariness for purposes of the Fifth Amendment right against self-incrimination. Taken together, these authorities demonstrate that Pennsylvania courts can and should ameliorate these concerns expressed by other jurisdictions by recognizing heightened protections against investigators' use of false statements in dealing with a suspect under Article 1, Section 9. I have to look that word up. I've never heard that word before. Sorry. Ameliorate is a formal verb meaning to make a bad or unpleasant situation better, more bearable, or improved. It specifically implies improving a negative condition rather than simply making a good thing better. Okay. Number 49, fourth, sound public policy dictates that Pennsylvania should extend Article 1, Section 9 to prevent the use of false statements during an interrogation. Indeed, even the U.S. Supreme Court has expressed its, quote, distaste for the deliberate misleading of a suspect by a police officer, end quote. The court has acknowledged that police interrogations are inherently coercive and contrary to public policy, because the, quote, deliberate or reckless withholding of information is objectionable as a matter of ethics, end quote. Number 50, the public policy implication of broadening protections for suspects is highlighted in criticisms of investigators' use of falsehoods generally and the Reid technique for interrogations, which is an interview technique that involves using deceptive tactics due to their coercive effect. See also Richard A. Leo, Inside the Interrogation Room, Crime, Law, and Criminology, 1996. I assume that's a article or a book. Finding in an observational study that police utilization of false evidence had 83% success rate in acquiring confessions. It was a study, I guess. Furthermore, it has been shown that, quote, the use of deception in interrogation increases the risk of eliciting false confessions, end quote. Foster 332A3D at 1194 and 9. Footnote 2. The court in Foster cited myriad academic support for finding an increased protection in this area. And then it says all these cases and studies and whatever, recommending that states pass laws prohibiting police from inter alia, outrightly misleading a suspect about the purpose of the interrogation, for example, indicating that he is a witness instead of a suspect. Makes sense? 51, a good example of the risk of using falsehoods comes from the recent exoneration of, quote, Central Park 5, end quote, who confessed to a crime they did not commit. State v. Griffin, 262A3D 44. Ecker J., concurring in part and dissenting in part. One of the exonerees explained, it's hard to imagine why anyone would confess to a crime they didn't commit. But when you're in that interrogation room, everything changes. During the hours of relentless questioning that we each endured, detectives lied to us repeatedly. It felt like the truth didn't matter. Instead, it seemed as though they locked onto one theory and were hell-bent on securing incriminating statements to corroborate it. A conviction rather than justice felt like the goal. And that's how it gets. That's why I don't think DAs should serve more than 2, maybe 3 terms, because it becomes an addiction for them to get conviction after conviction after conviction. They're not in it for what they started at. Number 52. Pennsylvania should not be content to secure quote-unquote constitutional statements at the expense of suspects' rights. Article 1, Section 9's right against self-incrimination demands more and should be extended to provide greater protection in the face of investigators' lies than the Fifth Amendment, just as our Supreme Court has suggested. Number 53. I think all states should have a Article 1, Section 9, to be honest with you. Number 53. Here, investigators knew LK was deceased even before they transported Ms. Virzi to headquarters for questioning. Yeah, you see that a lot in interrogations where they say, the suspect or the person being interviewed, they don't like to call them suspects yet, because then that hurts their lie. It hurts their reason for lying. But they always, when the person being interviewed inquires about the victim during their interview, they're always told, oh, we don't know yet. They're still working on him. And they know the person has passed. They knew that the minute they walked in that room. Most likely they knew it the minute they took that person into custody. And I just don't think it's fair. After picking Miss Virzi up, Sergeant Lippert stated to a colleague that he was picking up an individual to be questioned by homicide regarding a quote-unquote baby death case. Furthermore, Detective Curtis told Sergeant Lippert, prior to Sergeant Lippert transporting Miss Virzi to headquarters, that LK suffered critical injuries. Despite that knowledge, investigators presented falsehoods to Ms. Virzi like, quote, we don't know what we're investigating. It could be a crime. It could be an accident. We don't know what it is, end quote. Investigators also misled Ms. Virzi by telling her there were, quote unquote, cameras in the apartment and asking, quote, what's on the cameras? Despite knowing that the only cameras were baby monitors, likely with no relevant footage, such statements undoubtedly planted false thoughts in Ms. Virzi's head that ultimately led to both statements. Pennsylvania's Constitution should preclude that from happening. 54. Under these circumstances, where the Edmunds factors all indicate that Article 1, Section 9 provides greater protections for an individual's rights, the investigators here violated Ms. Virzi's rights under the Pennsylvania Constitution, and her involuntary statements must be suppressed. B. The warrantless copying of Ms. Virzi's cell phone must be suppressed. 55. At approximately 8:21 a.m. on June 16, 2024, while she was being held in police custody, investigators sought Ms. Virzi's consent to copy the contents of her cell phone. This warrantless seizure and subsequent warrantless search, and the search warrants later obtained based on the information those revealed, must be suppressed. I agree with that. I do agree. They fucked up. They shouldn't have searched those things until they had the warrant in hand. 56. Even if they give you consent, I would still get a warrant before I searched it, because I don't know. Just to cover my ass, I think. You've seen too many times where evidence has been suppressed because there was no warrant before the item was searched. 56. The Pennsylvania Supreme Court has expressly held that, quote, accessing any information from a cell phone without a warrant contravenes the United States Supreme Court's v. California and United States v. Worry. 57. Here, the discovery demonstrates that while Ms. Virzi was in custody, investigators obtained the passcode for Ms. Virzi's cell phone at approximately 8:21 a.m. on June 16, and also sought to copy its contents for forensic review, purportedly to obtain data associated with a picture of AK that had been sent to EK. Subsequent search warrants also reflect that investigators conducted a warrantless search of her phone because they acknowledged receiving, quote-unquote, information about what was on Ms. Virzi's cell phone, quote, during the course of interviewing Virzi, end quote. The warrantless rummaging around in Ms. Virzi's cell phone that resulted from this access undoubtedly violates both the Fourth Amendment and Article 1, Section 8. Footnote 3. In a supplemental report prepared on July 17, 2024, investigators indicated that they, quote, observed the application ID for Google Chrome, end quote, while reviewing the download of Virzi's cell phone and viewing images taken from the phone. While the reports are vague about when this review occurred, the undisputed facts demonstrate that investigators had unlimited access to Ms. Virzi's phone and the passcode to unlock it for nearly the entire duration of her detention on June 16, 2024. So there you go. 58. Moreover, Ms. Virzi's consent to the illegal phone copying does not make it constitutional. Any such consent must be both knowing and voluntary. Commonwealth v. Gallagher, discussing voluntariness and totality of the circumstances analysis in context of cell phone imaging. Here, for all the reasons stated above, any consent was neither knowing nor voluntary. The investigators downplayed the significance of what they were asking for by acting as though they did not particularly understand technology, a tactic aimed at making the request seem like it was not a big deal when it unequivocally was. Nor did they explain what Ms. Virzi's rights were related to the contents of her cell phone. What Ms. Virzi's rights were related to the contents of her cell phone, period. Finally, for all the reasons discussed above, the circumstances surrounding the detention were highly coercive, and thus any consent was involuntary, and the fruits of investigators' warrantless search should be suppressed. C. The fruits. I don't think that a verbal consent should ever be used, to be honest with you. There's too many ways that can go wrong in the end, and that can make that evidence unpresentable. You know what I mean? I think they should do away with verbal consent. I'm sorry, I just do. I know that makes the police officer's job that much harder on scene in the actual, live event, but I just think that it's better for everybody, and you have less reasons to ask for suppression of evidence when you have a paper warrant in hand. I just do. And I think that we're spending too much of the taxpayers' money on all of these motions and all these court costs when this can all be avoided by making it a rule or making it policy that you have to have a paper warrant in hand before you can search anything. Verbal consent doesn't count. And then you cut all these court costs, and you cut the spending of the taxpayers' money. I mean, just little things like that, I mean, the Karen Reed trial cost millions for one trial. So times that by 2 for a trial. The first trial should never have happened. And then you have a second trial? You're retrying her? For what? For your ego? Fuck that. I mean, somebody has to draw the line. Somebody has to put a limit on what the DA can do. I mean, I don't think that they should be untouchable. I don't think judges should be untouchable. I think if the judge is caught doing something wrong, they should be held fully accountable. The fact that you can't investigate a judge or discipline a judge is bullshit. Then you get a dirty judge on the bench that can data, files, and folders, which include personal communications in the form of texts, writings, phone numbers, contact lists, call history, including FaceTime calls, SMS messages, MMS messages, iMessages, chats, text communication on all on applications capable of sending and receiving text messages and calls, video calls, contacts contained in the phone, GPS information and or device location history, and photos with and or of AKLKSREK. That's the family of her best friend. From 6/12/24 through 6/16/2024, end quote. 60. Included in the laundry list of items investigators sought is a request for, quote, all electronic data, end quote, from Ms. Virzi's phone. A request that, on close inspection, far exceeds any purported, quote unquote, consent obtained from Ms. Virzi, and in any event is far too overbroad and intrusive given what investigators had probable cause to seek at that time. The fruits of such an overbroad search, including web browsing history and search history, as well as the subsequent search warrants obtained based on such data, must all be suppressed. So now they take the chance of not only losing what they found during that initial search of her phone before they had a paper warrant, but the warrants that they acquired based on what they found on that initial search are at risk of also being suppressed, which means anything from that they found on those search warrants is at the risk of, is at risk of being suppressed. So you have all this work done and you take the risk of it being suppressed because of one verbal consent rather than getting a written warrant. Her phone wasn't going anywhere, right? She was in custody. She was being she was being detained. She was handcuffed. So she didn't have possession of her phone. So why couldn't you take the time to get a paper warrant? Just one second, I'm going to take a drink. I hope that's muting, because last time when I hit my mic to mute it, you could still hear me swallowing, and I know people have issues with that, so I hope that was muted. If it wasn't, I apologize. 61. The U.S. Supreme Court has recognized that cell phones, quote, place vast quantities of personal information literally in the hands of individuals, end quote. Therefore, quote, a search of the information on a cell phone bears little resemblance, end quote, to a brief physical search, as has been previously considered by the Supreme Court, Riley v. California. Accordingly, the Supreme Court requires police to generally secure a warrant before searching the data on cell phones. ID. 62. In Pennsylvania, it is well established that search warrants shall only be issued upon a finding of probable cause based on one or more affidavits. Furthermore, in deciding whether probable cause exists, the issuing authority may not consider any evidence outside the four corners of the affidavits presented. See also Commonwealth v. Harlan. Quote, the task of the magistrate acting as the issuing authority is to make a practical, common sense assessment of whether, given all the circumstances set forth in the affidavit, a fair probability exists that contraband or evidence of a crime will be found in a particular place. A search warrant is defective if the issuing authority has not been supplied with the necessary information. Number 63. The Pennsylvania Superior Court has interpreted the Fourth Amendment's requirement of particularity in search held that courts trying to determine if a warrant is overbroad, ambiguous, or both must first determine, quote, for what items probable cause existed, end quote. The court must then determine, quote, the sufficiency of the description in the warrant against those items for which there was probable cause, end quote. Like, you can't just fill out a paper warrant and say, we want to search the house. You have to say what you're looking for, first of all, because if you're looking for blood on items, then you're going to want to search the closet or the laundry. You're going to want to search areas where there's clothing, okay, if the crime happened elsewhere. You're going to want to look in the garbage for weapons or clothing. You're going to want to look in the fireplace or wherever. But you can't just say, we want a search warrant for the house Like, you can't be digging through the kitchen cabinets for bloody clothes. Okay? I mean, that doesn't fit. So they have to narrow it down and convince the judge that they have probable cause from what they know at the time that they fill out the warrant to honor a warrant to look for supporting evidence for that probable cause. But the areas that you want to search have to fit the evidence that you're searching for. Like, let's look at Afro Man. They were looking in his closet for a kidnapped woman that was supposedly being kept in his basement. What the fuck? They were looking in the pockets of his clothes. But their warrant was for a kidnapped woman that was supposedly being kept in his basement. Those don't match. You can't do that. You have to go back and get another warrant if for some reason you think that you saw something in his closet on the way to the basement that is evidence in your case. You have to go back and get a warrant to search that area and search that item. You can't just say, oh, I saw it on my way to the basement. It doesn't work that way. Defendants have rights. Suspects have rights. And the cops need to take that into... The cops forget that they can very well be on the other side of the table at some point, and how they must kick themselves for the way they treated persons of interest during their time as a detective. If they are ever found to be on that other side of the table, they probably, their empathy probably skyrockets at that point, but then it's too late. Now you want fair treatment. You didn't give any of those people fair treatment. You lied to them. 64. The court in Thompson held that courts trying to determine if warrant is overbroad, ambiguous, or both. Okay, I read all that. Finally, based on the answer to the previous two questions, the court must suppress the fruits of the search to the extent there is, quote, any unreasonable discrepancy between the items for which there was probable cause to search and the description in the warrant. Okay, so they're right there the same. Does the items that you had probable cause to search match what you wrote in the warrant? Or are you just hyping the warrant up to get in, and then you're going to go look for the probable cause evidence? You know what I mean? A lot of cops do that. But if the defendant has a good lawyer, that lawyer will get it suppressed, and then you're fucked. What if that's the only evidence you have against the suspect? And now this guy did do the crime, and they're going to walk free because you weren't honest in your warrant description. You just used it to get in the door, and then you just, took free reign of the whole property. You can't do that. If you have a warrant to search inside the house, you can't search in the backyard. Okay? You just can't. If you have a warrant to search the car, you can't search the house. It doesn't give you free reign to search everything. You have to search what that warrant describes. And that's it. If you want to search somewhere else, you have to go get another warrant. 65. Commonwealth v. Butler. The court in Johnson noted, quote, even where there is probable cause to suspect the defendant of a crime, police may not search his or her cell phone to look for evidence unless they have information establishing the existence of particularized evidence likely to be found there, quote. And then when you get the warrant to search the phone, you can only search what the warrant specifies. You can't get a warrant to search the contacts in their phone and then go into all their data. You can search the contacts and that's it. You can't get a warrant to search the text messages and then search the IMs and everything. Your warrant specified text messages. It didn't specify SMS. It didn't specify MMS or, whatever. You can't go into their Instagram and look and search their messages there, because those aren't on the phone. Those aren't text messages that are included in the phone messaging app. They're on a separate app that happens to be on the phone. You see what I'm saying? And even if it's not on the phone, you can't get online and search their Facebook just because you got a warrant to search their phone text messages. I mean, Facebook, yeah, has Messenger, but you didn't get a warrant for Facebook. You got a warrant for the phone text messages. Okay. Citizens enjoy greater protections under Article 1, Section 8 of the Pennsylvania Constitution than under the Fourth Amendment. Footnote 4. Article 1, Section 8 provides greater protection than the Fourth Amendment. Okay, well, that didn't really help us out any. Where was that? Okay. And as such, the Commonwealth must provide greater specificity. I hate that word. Specificity in an affidavit of probable cause. The language of the Pennsylvania Constitution requires that a warrant describe the items to be seized, quote, as nearly as may be, end quote. The clear meaning of the language is that a warrant must describe the items as specifically as is reasonably possible. This requirement is more stringent than that of the Fourth Amendment, which merely requires particularity in the description. 66. Here, investigators could not and did not identify any particularized evidence that they believed likely to be found in Miss Virzi's phone beyond her call log, text messages, and photos taken during the time LK was in her care. In other words, the warrant application seeking, quote, all electronic data is substantially overbroad. I agree. 67. This court should not countenance the investigators' efforts to obtain the entire contents of Ms. Virzi's phone on the threadbare assertion that, in Detective Triolo's experience, quote, it is not uncommon for the contents of the cellular phones of actors and or individuals associated with violent crimes to provide valuable evidence related to the criminal incident, end quote. Yeah, but you have to specifically request to search it for that. Put a different way, criminals use phones. In fact, everyone uses phones, and that unremarkable statement cannot provide the basis for unlimited rummaging through a person's phone. 5. To be clear, even if investigators could, arguendo, establish probable cause to seek call logs, text messages, and photos because those specific phone uses were all tied to Ms. Virzi's trip to visit with the parents, such probable cause does not, however, give free rein to investigators to review everything else on the phone as occurred here. I have to agree. The probable cause standard requires specificity, tying specific phone use to specific elements of the charged crimes, and the Commonwealth's boilerplate language in the warrant lacks any such specificity. Police may not rely on the general ubiquitous presence of cellular telephone institute for particularized information that a specific device contains evidence of a crime. 68. Like if you believe there's pictures of the crime or a video of the crime happening, you have to specify that you want to look at the pictures and video in that phone. You can't get a warrant for the phone text messages and then, oh, I came across this video on the phone and it's a video of her committing the crime. It doesn't work that way. You have to go get another warrant. 68. The U.S. and you better not have found that video before you get the warrant. Because even if you get a paper warrant, if you found it before you got the warrant, that doesn't fly. You can't search the phone, find what you need, and then go get a warrant that specifies what you want to get off that phone. You can't do that. You have to fill the warrant out for what you want off that phone, and then that's all you are allowed to look for on that phone. And you can't You can't accidentally come across a video. I'm sorry. That's not how phones work. And you better have probable cause for why you think there's a video of the crime on the phone. You can't just, oh, I think there's probably a video of it. No, you have to give probable cause why you think there's a video of the crime on the phone, and then file for a search warrant specifically for the video. And then you can go into the phone, into the videos only, not pictures, videos, to see if that video's on there. The U.S. Supreme Court has summed this common sense limitation up quite well on at least two occasions. In 1926, Learned Hand observed that it is, quote, a totally different thing to search a man's pockets and use against him what they contain from ransacking his house for everything which may incriminate him, end quote. That's exactly what I just said. Or, about Afro Man. If his pockets contain a cell phone, however, that is no longer true. Indeed, a cell phone search would typically expose to the government far more than the most exhaustive search of the house. A phone not only contains in digital form many sensitive records previously found in the home, it also contains a broad array of private information never found in a home in any form, unless the phone is. 69. Put differently, the assertion that criminals use phones lacks the required specificity and thus is insufficient to establish probable cause and obtain a warrant that sweeps as broadly as the investigator's warrant did here. See Commonwealth versus Annie. Recognizing that categorical assumptions cannot be the sole justification for probable cause, and noting that while certain crimes may lend themselves to certain assumptions about cell phone use, not all do. That is particularly true as it relates to the web browsing and search history here, where investigators offered no evidence linking such use to the violent crimes at issue. C. Johnson, 240A3D at 575, requiring a specific nexus between the crime and cell phone data to be searched. Investigators should never have been given access to such information, and as such, it should be suppressed as the fruit of the poisonous tree. I agree. The fruit of the poisonous tree doctrine excludes evidence obtained from or acquired as a consequence of lawless official acts. Number 70. We still have 22 pages. Moreover, because investigators obtained subsequent search warrants on July 9, 2024, seeking all data from 1 year prior to June 16th, November 21, 24, seeking all records associated with Ms. Virzi's Google account and her Google Chrome app, and November 26, 2024, seeking the same from Google. And because those requests were based at least in part on the information illegally obtained from the first time the police took a forensic image of Ms. Virzi's phone, in particular based on information about Ms. Virzi's web searches, the fruits of those subsequent searches are all tainted by the initial illegality and should similarly be suppressed. That's what I'm talking about when I say that all the evidence that you got from warrants that you applied for as a result of that initial illegal search in his basement, okay? And somehow you came across a bloody knife in the pocket of his pants that were in the dirty laundry, okay? In his bedroom, in the dirty laundry. And you go and you file for a search warrant to search his bedroom, more specifically his clothing, both in his closet and his dirty laundry, in order to use that knife as evidence, okay? And it's granted. And so you go back and you get the knife out of the pants pocket and you submit it as evidence, and it has the victim's blood on it. And
Mr. Afroman's fingerprints. So as a result, you arrest him for the crime. The defense attorney can have all of that thrown out. And that's the only evidence you have against him, and you don't have any, you can't find any other evidence showing that he's responsible for the crime. That defense attorney can apply to have the clothing, the knife, the fingerprints, the blood, the victim's blood, all of that suppressed, because what were you doing in his dirty laundry searching the pockets of his jeans when you were supposed to be searching the basement for a kidnapped woman? And if you didn't do that illegally, then how did you know there would be a bloody knife from a different crime in his pants pocket? You're there specifically to search for a kidnapped woman in his basement, and you find the murder weapon of a different crime, and you want to arrest him on that crime. How are you going to justify a warrant for those pants, to get that knife, to justify having that knife with all that evidence on it? You shouldn't have even been in his bedroom. The only place you should have gone is to the basement. So all that gets thrown out and he walks. See what I'm saying? I mean, follow the rules. It's not that hard. We have to live by the laws. You should have to follow the rules of evidence. It's called doing your job. Any of us that work have to follow rules at our job. They're called policies, and they're in place for a reason. So there's that. Where was I? Am I back? Okay. Number 70. Moreover, because investigators... Okay, wait. No, I already did all that. Okay. The exclusionary remedy for illegal searches and seizures extends not only to the direct product of the illegality, the primary evidence, but also to the indirect product of the search or seizure, the secondary or derivative evidence. Finding that subsequent searches derived from an initial illegal search are themselves illegal. Number 71. Here, because all the search warrants for information from Ms. Virzi's phone were premised on illegally obtained information from the unconstitutionally overbroad July 1, 2024 search warrant, and each subsequent search warrant specifically identifies certain information about Ms. Virzi's web searches and internet browsing history, information that was obtained illegally, all evidence extracted from Ms. Virzi's phone as a result of the July search warrants must be suppressed as fruits of the poisonous tree. D. The notice of intent to seek the death penalty must be dismissed as unconstitutional because any fact that increases a defendant's sentence, like the statutory aggravating factors, must be alleged in the charging document and presented for probable cause review. Number 72. The notice of intent to seek the death penalty and notice of aggravating factors, which quote-unquote death penalty notice, filed by the Commonwealth to seek the death penalty and select which aggravating factors will be used to support a sentence of death, and to allow defendants to waive the constitutional right to a preliminary hearing before notice of that decision must be given.
violates defendants' rights under the 5th, 6th, and 14th Amendments of the United States Constitution and Article 1, Sections 9 and 10 of the Pennsylvania Constitution. Given this, the court should dismiss the constitutionally infirm death penalty notice filed in this case. Number 74. It is well settled that, quote, under the Due Process Clause of the Fifth Amendment, footnote 6, no person shall be deprived of life, liberty, or property without due process of law. Okay. It is well settled that under the Due Process Clause of the Fifth Amendment and the Notice and Jury Trial Guarantees of the Sixth Amendment, any fact other than prior conviction that increases the maximum penalty for a crime must be charged in an indictment submitted to a jury and proven beyond a reasonable doubt. The, quote, 14th Amendment commands the same, end quote, as it relates to both state and federal cases. Okay. Number 75, the requirement that prosecutors must charge facts that increase the maximum penalty in an indictment is based on a long line of Supreme Court cases that recognize, quote, if a state makes an increase in a defendant's authorized punishment contingent on the finding of a fact, that fact, no matter how the state labels it, must be found by a jury beyond a reasonable doubt, end quote. Ring v. Arizona, concluding the principle applied in Apprendi applies with equal force to facts increasing the mandatory minimum which a jury must find exists beyond a reasonable doubt. In federal prosecutions, such facts must also be charged in the indictment. Number 76, Apprendi and Elaine have been extended to facts used to increase a sentence. It is undisputed that the death penalty increases the punishment for first-degree murder. Number 77, the core, quote, purpose of an indictment or an information is to satisfy the requirements of the Sixth Amendment and Article 1, Section 9, which enunciate the right to formal notice of charges, end quote. The Pennsylvania Supreme Court has held that no matter, quote, the source of the notice guarantee, the salient point is that Apprendi, end quote. Established, quote, that a fact increasing a statutory maximum must be treated as an element of the defense, end quote, of which notice must be given. This directive, by its own terms, includes the need to provide sufficient notice in the charging document when the Commonwealth intends to seek an enhanced sentence like the death penalty. Number 78, by way of background, in federal cases, the government cannot file a notice of intent to seek the death penalty before it presents the aggravating factors to a grand jury for a probable cause finding and includes those aggravating factors in the indictment. That's what I just said. Noting that the logic of these cases applies equally to the Fifth Amendment and thus requires statutory aggravating factors to be alleged in the indictment in capital cases. The government is required to charge by indictment the statutory aggravating factors it intends to prove to render a defendant eligible for the death penalty, and its failure to do so in this case is constitutional error. 79. And if that's true, then they need to drop the death penalty. They need to take it off the table. Number 79, the procedure of presenting the aggravating factors to a grand jury for probable cause determination is based on holdings by courts under the Apprendi line of cases that recognize statutory aggravating factors increase the maximum sentence. Factors to be subjected to a probable cause finding. I mean, if you have to present your case in front of a grand jury in order to have a person indicted on murder charges, why wouldn't you have to present to the grand jury if you're seeking the death penalty? If that's the maximum, I mean, you better be damn sure that it's fitting of the crime. And why wouldn't you, I mean, yeah, why wouldn't you take it in front of the grand jury? I don't understand. That's a fuck up on the district attorney, as far as I'm concerned. They screwed that up royally, if that's the case. 80, Article 1, Section 10 of the Pennsylvania Constitution provides as follows: initiation of criminal proceedings, twice in jeopardy, eminent domain, except as hereinafter provided, no person shall, for any indictable offense, be proceeded against criminally by information, except in cases arising in the land or naval forces or in the militia when in actual service, in time of war or public danger, or by leave of the court for oppression or misdemeanor in office. Each of the several courts of common pleas may, with the approval of the Supreme Court, provide for the initiation of criminal proceedings therein by information filed in the manner provided by law. No person for the same offense no person shall, for the same offense, be twice put in jeopardy of life or limb. This is the double jeopardy. And without just compensation being first made or secured. So I think what they're saying is it's too late to go in front of a grand jury to get the death penalty approved, because then they would be presenting their case a second time, and that would be considered double jeopardy, I believe. Just one second. They would have to somehow present another case that is worthy of the death penalty. 81. In Commonwealth v. Webster, the court determined that Article 1, Section 10 did not violate equal protection by allowing counties to adopt procedures to initiate criminal cases by information, because inter alia, the, quote, rights of an accused at a preliminary hearing are far greater than those afforded him in the operation of an indicting grand jury, end quote. 82. Indeed, the Pennsylvania Supreme Court has recognized that when cases are initiated by criminal complaint, defendants have a right to a preliminary hearing during which a judge must make a probable cause finding on that criminal complaint. This is a critical stage of the criminal proceedings. At the preliminary hearing, it is incumbent on the Commonwealth to establish at least prima facie that a crime has been committed and that the accused is the one who committed it. In order to satisfy this burden of establishing prima facie case, the Commonwealth must produce legally competent evidence which demonstrates the existence of each of the material elements of the crime charged, and legally competent evidence to demonstrate the existence of facts which connect the accused to the crime charged. Number 83. Because there's a list of things that have to be met before you can find somebody guilty of first-degree murder. And that's why a lot of the times the DA will charge them with less including charges, a lesser included charge, so that in case they don't check off all the requirements for first-degree murder, they can come back with manslaughter, because they did check all the boxes for that. You have to have a pretty solid case to only charge somebody with first-degree murder and expect nothing else and expect a guilty verdict. But a lot of juries decide their verdict on their personal feelings that was presented to them, and that's where we get the guilty verdicts for somebody that was not proven guilty. And so it's not a foolproof way of doing things, but I guess it's the only fair way to do things. But I don't know. Number 83, the defendant has not located a written procedure adopted by Allegheny County and approved by the Supreme Court as contemplated by Article 1, Section 10, which would allow for the initiation of proceedings by information. Assuming, however, such a procedure has been adopted and approved, it is presumed those procedures are in accordance with the rules of criminal procedure, which provide that when the Commonwealth initiates a criminal case by criminal complaint, it is required to present the charges to a magistrate for a probable cause finding. And if the magistrate does not find probable cause, the charges are dismissed. 84. Since due process requires, at a minimum, that a criminal defendant be provided notice of the charges against him and an opportunity to be heard, a criminal information can only be valid if it is preceded by specific notice to the defendant of the crime charged and presentment to a neutral magistrate who must then determine that a prima facie case has been established. Neither an indictment nor an information may be filed against a defendant unless the Commonwealth has first established prima facie case of the defendant's guilt to the satisfaction of a neutral judicial officer at a preliminary hearing. Number 85. Here, in accordance with the current practice in Pennsylvania, the Commonwealth did not present a prima facie case of the aggravating factors for a probable cause finding. This practice violates the Pennsylvania and United States constitutions and fails to provide due process to a defendant. In this case, the Commonwealth did not file its information and notice of intent to seek the death penalty until August 22, 2024, almost a month after Ms. Virzi waived her right to a preliminary hearing on July 24th. This violated Ms. Virzi's constitutional rights in two ways. Okay, so what they did is they charged her in July with murder, but they didn't say they were going to seek the death penalty. So she waived her right to a preliminary hearing and thought that that was it. Well, then they came back on August 22nd and filed a notice of intent to seek the death penalty. This is a month later. Well, she's already waived her right to a preliminary hearing on the murder charge. And now you want to throw in the death penalty, and she doesn't have a chance to defend herself for that. So you either have to do it all at the same time, or now you have to give her a preliminary hearing on the death penalty, on, seeking the death penalty. And I don't think that's an option. So it shouldn't be an option for the death penalty should be taken off the table then, because that wasn't part of what they provided to her when she made the decision to waive her right to a preliminary hearing. Her decision to waive her right to a preliminary hearing might have been different if she knew that they were seeking the death penalty, and she didn't. This violated Ms. Virzi's constitutional rights in two ways. First, allowing the Commonwealth to unilaterally file death penalty notices without a probable cause finding by a judge violates defendants' due process rights by allowing the Commonwealth to unilaterally decide to seek the death penalty without an independent check of the propriety of that decision by a neutral party such as a magistrate. The Commonwealth's unchecked power in this regard is not only unconstitutional, but it also leaves the door open for egregious abuses of power, as has been demonstrated in recent cases in Washington County, Pennsylvania. Then they quote a link that they embedded of petition filed by the Pennsylvania Supreme Court regarding Washington County Court of Common Pleas case. Arguing that Washington County District Attorney has filed notices of intent to seek the death penalty as a bargaining tool, and that, quote, the Washington County District Attorney that is bullshit. So they're not able to prove to a magistrate that they can establish prima facie for first-degree murder charge, but they want to add the death sentence as a bargaining tool to get somebody to make a plea bargain with them. Well, you can't do that because the death penalty is not even on the table. because you haven't even proven your case for first-degree murder charge, right? Second, the constitutional deficiencies in Pennsylvania's statutory scheme for presenting the aggravating factors are brought into stark relief here, where the Commonwealth cannot establish a prima facie case for at least two of the aggravating factors identified in its notice. One, that the alleged killing occurred in the perpetration of a felony. And two, that Ms. Virzi has a, quote, insignificant history, unquote, of felony convictions, which she has no record. Number 88, as for whether the alleged killing occurred during the perpetration of a felony, no such felony was alleged in the criminal complaint. And thus, Ms. Virzi should have been given an opportunity to challenge that element. C, Commonwealth v. Edmiston, requiring a crime that is, quote, separate and distinct from the crime of murder, end quote, occurring at the time of the killing. As for whether Ms. Virzi has, quote, a significant history of felony convictions involving the use or threat of violence to the person, end quote, the Commonwealth not only failed to present any evidence supporting these allegations at the preliminary hearing stage, but it could not have done so because Ms. Virzi has no criminal history whatsoever. These facts show how the Commonwealth's unchecked power to unilaterally choose to allege aggravating circumstances without due process or judicial oversight can lead to false and unsupported allegations. Footnote 8. Because the Commonwealth unilaterally identified at least two aggravating factors that lacked factual support in its notice of intent to seek the death penalty, the court could, in the alternative, strike the notice of intent. Just 1 second. I'll be right back. That's the problem with a lot of these district attorneys is they are in office for so long and they get used to not being challenged, or getting their card punched. I mean, so they get power hungry and they tend to think that they don't have to follow the rules of evidence or anything else. They just do what they want and they ask for the judge to forgive them later. It's easier to ask for forgiveness than permission, And it happens too often. They need to be held accountable for their actions. And that's what I mean about the fact that the DA is untouchable and the assistant DAs are untouchable is bullshit. Because then they can just do whatever and not have to worry about being held accountable for it. All they have to do is apologize to the judge and promise not to do it again until they do it again. Nothing happens to them. And maybe if something did happen to them, they would be less likely to do it. Isn't that how you deter bad behavior? You punish them for the bad behavior. Then you make them not want to do the bad behavior. It's aggravating because a lot of this shit can be sidestepped if they just change the rules a little bit. I mean, these rules were made up in, the beginning of the country. I mean, things change. Sometimes you have to change with the time. That's all I'm saying is, okay, you don't have to change the Constitution, just add some adjuncts to it, right? Or amendments or whatever you call it. Oops, sorry. What did I do? Shit. Let's go back. Sorry about that.
Is it sharing? It's not sharing, is it? God damn it. Now is it sharing? Okay. Sorry about that. 89. Third, to the extent that Pennsylvania law and rule of criminal procedure 802 permits the Commonwealth to avoid giving notice of the aggravating factors until after a defendant has waived the right to a preliminary hearing, such as rule is unconstitutionally vague and overbroad. Pennsylvania are criminology, whatever. While Rule 802 requires the Commonwealth to provide notice of its intent to seek the death penalty to the defendant at or prior to the arraignment, the language of the rule does not delineate between a preliminary and formal arraignment. The application of this language to mean the formal arraignment after waiver of a preliminary hearing and or the hearing itself violates the notice requirements in the Sixth Amendment and Article 1, Sections 9 and 10, as well as the 14th Amendment, thus making this rule unconstitutional. For all these reasons, the court should strike the death penalty notice filed in this case. Number 90. This court should determine that the Pennsylvania sentencing scheme, which allows the district attorney to file a notice of intent to seek the death penalty, thus increasing the maximum sentence, without presenting the notice for a probable cause finding, is unconstitutional. Alternatively, this court should strike the death penalty notice as to Ms. Virzi because, as applied in this case, the service of the notice after Ms. Virzi waived her preliminary hearing violates procedural due process and Article 1, subsection 9 and 10 of the Pennsylvania Constitution. E. The notice of intent to seek the death penalty must be stricken because Pennsylvania's system of capital punishment violates both the U.S. and Pennsylvania constitutions. 91. The due process clauses of the 5th and 14th Amendments to the U.S. Constitution and Article 1, Section 9 of the Pennsylvania Constitution require that due process be afforded to those whom the government seeks to deprive of life, liberty, or property, while the 8th Amendment to the United States Constitution and Article 1, Section 13 of the Pennsylvania Constitution command that inflicting cruel punishments is unconstitutional. Number 92. I don't get how a state can be a death penalty state, and yet in their state constitution, they claim that inflicting cruel punishment is unconstitutional because the death penalty is cruel punishment. I mean, it's the cruelest you can get, right? So how can you say that in your state constitution that that's unconstitutional, but yet you're a death penalty state? How is that possible? It seems like that's double sword there, you know? I don't know. Okay. Um, 92. The Eighth Amendment precludes the infliction of cruel and unusual punishments. U.S. Constitution, Amendment 8. The Supreme Court has recognized that a claim that punishment is excessive is judged not by the standards that prevailed cruel and unusual punishment in violation of the 8th and 14th Amendments. Furthermore, the 8th Amendment forbids, quote, the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed. Number 94. Each state's capital punishment system must be examined on an individual basis, which I also don't get. How is it different from one state to the next? The Pennsylvania Supreme Court upheld its own capital punishment statute, footnote 9. Okay, that just gives the statute site. The Pennsylvania Supreme Court upheld its own capital punishment statute by determining that it, quote unquote, diligently attempted to prevent the wanton and freakish, arbitrary, and capricious imposition of the death penalty. However, this holding must be re examined in light of the evolving standards and attitudes that currently prevail in today's culture, recognizing the cruelty of the death penalty resulting from its lack of reliability, arbitrariness, and excessive delays. That's what I was saying. You have to bring them current with the times. See State v. Gregory, finding the death penalty is unconstitutional on the basis of being cruel punishment, quote, because it is imposed in an arbitrary and racially biased manner and fails to serve any legitimate penological goal, end quote, and a case-by-case review of death sentences cannot fix the constitutional deficiencies in the death penalty sentencing scheme. I'm assuming since they said it was a racially biased manner of death, they were probably talking about hangings. Holding the history of capital punishment in Connecticut and other recent legal developments compels the conclusion that the death penalty now constitutes cruel and unusual punishment in violation of the state constitution. Holding the death penalty is unacceptably cruel under contemporary standards of decency, and the death penalty is administered with unconstitutional arbitrariness and discrimination. Number 95. These decisions show how the principles articulated in the Eighth Amendment are not static concepts. To the contrary, that provision, quote, must draw its meaning from the evolving standards of decency that mark the progress of a maturing society, end quote. Consistent with that goal, the Supreme Court inescapably has the duty, as the ultimate arbiter of the meaning of our Constitution, to say whether when individuals condemned to death stand before the High Court's bar, moral concepts require the court to hold that the law has progressed to the point where the court should declare that the punishment of death, like punishments on the rack, the screw, and the wheel, is no longer morally tolerable in our civilized society. By prohibiting inhumane treatment of even those who have committed the most serious crimes, the Eighth Amendment reaffirms the duty of the government to respect the dignity of all persons. The basic concept underlying the Eighth Amendment is nothing less than the dignity of man. Number 96. Consistent with these long recognized principles, the court should strike the notice of intent to seek the death penalty in this case as incompatible with the Eighth Amendment and Article 1, Section 13 on the ground that it is unreliable, arbitrary, and causes excessive delays. Roman numeral 1, the death penalty is not reliable. Number 97, for it is well documented that courts and others have long questioned various aspects of the death penalty's reliability. I would say it's pretty reliable. You're either dead or you're not at the end. For example, in U.S. v. Fell, the court found that the evidence introduced at the hearing supports a finding that the procedures for conducting jury trials mandated by the Gregg decision have not cured systemic shortcomings in jury selection and jury deliberations. I agree with that. The death qualification process continues to weight jury panels in favor of conviction and in favor of the death penalty through the exclusion of a large portion of the community which holds views opposed to the death penalty. When surveyed, jurors who actually served in capital cases had great difficulty in following the trial court's instructions. This is what I was talking about when I say that they let their feelings instead of following the evidence. It is an inadequate response to presume that juries follow our instructions when the evidence is to the contrary. The evidence introduced at the hearing demonstrates that despite efforts to create a more just death penalty regime, the FDPA, like the very similar state death penalty statutes enacted after Furman, remains inherently unreliable as it seeks to identify those cases in which death is the just outcome. Number 98. Furthermore, according to the Death Penalty Information Center's death penalty census, wow, say that 10 times really fast.
More than 9,922 death sentences have been imposed between 1972 and July 1, 2024. Footnote 10. Death Penalty Census, Death Penalty Info Center. Okay. Based on that research, the organization concluded that, quote, the single most likely outcome of a death sentence in the United States is that the sentence or conviction is ultimately overturned and not reimposed, end quote. In fact, since 1973, 200 individuals sentenced to death in the United States have had their convictions overturned. Footnote 11. Innocence Death Penalty Info. Okay, it's just showing where to go for that study, I guess. By implication, this almost certainly means that the federal and state governments have executed innocent people due to the fundamental unreliability of capital punishment systems. Well, how is that any different than somebody serving life? How is that any different than an innocent person serving life? You're going to get that. It's going to happen. So what? That just means that we should have more life sentences dealt out? I mean, we're human. There are going to be mistakes. And for people to think that otherwise is stupid, is absolutely ridiculous. You're living under a rock if you think there's not going to be mistakes made in every aspect of your life. Surgeons make mistakes. Cops make mistakes. Juries make mistakes. Courts make, but that's why you have appeal processes. And that's why you have the legal system. Okay? But it's going to happen. We're only human. And as far as I can see, AI makes mistakes because there have been some lawyers that have cited cases that they got from Chat GPT only to find out, and they cited those cases in court only to find out from the judge those cases are not real. So even AI makes mistakes. Number 99. In Pennsylvania, from September 1978, when Pennsylvania enacted 42 Pennsylvania I don't know what that is, to 2015, of the 408 prisoners sentenced to death, 191 had been sentenced to life in prison or less or released. That amounts to 46.8% of the total. Footnote 12. Just shows the website for that study. Out of that, 191, 169, out of that 191, 169 were resentenced to life, 41.4%. 16 were resentenced to a term of years, 3.9%, and 6 were exonerated, 1.5%. Of the 181 remaining individuals on death row, 44.4%, 28 of those individuals have had their convictions or death sentences overturned but were awaiting further court proceedings. 6.9%. 33 had died on death row other than by execution, which is 8.1%, and 3 had been executed, 0.7%. So what's the problem? We're not even executing the ones that are on death row. So 100. Members of the U.S. Supreme Court have described the number of instances where an individual was sentenced to death and later exonerated as quote-unquote disturbing, even though that statement was made at a time when there had only been 60 exonerations in capital cases. Okay, I'll give you that. It is disturbing. But so is a surgeon by juries of our peers. They have no special education in how to be a juror. They don't get a, quick class on becoming a juror. They are thrown in the lion's den and they are made to make a decision on the facts that are presented to them. So I find that less disturbing than a experienced licensed surgeon who took the wrong organ, who removed the wrong organ. And that just happened a couple weeks ago or a month ago in Florida. So, I mean, I feel like you're overstating this a bit, especially if only how many did they say, 0.7 are actually ever executed? Come on now. Okay, so members of the U.S. Supreme Court have described the number of instances where an individual was sentenced to death and later exonerated as quote-unquote disturbing, even though that statement was made at a time when there had only been 60 exonerations in capital cases. That number and its disturbing nature has only increased since. 101. The overwhelming evidence shows that the death penalty is not 100% accurate and is as fallible as any human being. Well, that's because the human beings are the ones that hand down that punishment, right? If not more so. Roughly 53.7% of individuals sentenced to death in Pennsylvania have had their sentences overturned, received at least a lesser sentence, or at most a full exoneration. That means in Pennsylvania, less than half of the individuals sentenced to death have continued to be imprisoned on death row, while less than 1% have actually been executed. But how much of that is because they have such a long appeals process? They get how many appeals? Each prisoner gets how many appeals? And those appeals each take how many years? Okay? So yeah, the time that they're imprisoned on death row until they are actually executed is a long time because we give them so many steps and so many chances to get off of death row and to be found not guilty or have their sentence lessened. So you want us to take those opportunities away from them? Do you want us to take the appeals process away from them? Because then we're violating their constitutional rights to appeal their verdict. So which is it? You can't have both ways. You can't have them on death row for a short amount of time till their execution and still give them all the rights that they're entitled to for their appeals. You can't have it both ways. It is what it is. This is not only a disturbing statistic, but an objective representation of the complete unreliability of Pennsylvania's capital punishment system. Roman numeral 2. The death penalty is arbitrary. 102. The death penalty is also imposed in an arbitrary manner. Indeed, the two most significant predictors of whether the death penalty will be imposed in a particular case are: 1, the state in which a crime occurs, the strongest predictor of whether a death sentence will result. Excuse me. And 2, whether the murder victim is white. Oh, it's always got to come in. It's always got to come in. Additionally, even though, quote, deterrence of future murders is identified as a basis for the death penalty, end quote, the reality is that the statistics do not bear this out. 103. The Western District of Pennsylvania acknowledged the Fell Court's analysis constitutionality of the death penalty, but like in Fell, ultimately held that institutional authority to change this body of law is reserved to the Supreme Court. And for this reason, the trial court is required to deny the defense motions related to the constitutionality of the death penalty, end quote. However, the time has surely arrived to recognize that the reforms introduced by Gregg and subsequent decisions have largely failed to remedy the problems identified in Furman. Number 104. Further underscoring the arbitrariness of death penalty jurisprudence are decisions from the Supreme Court that have, at various times, granted relief from the death penalty in cases involving some of the most egregious facts imaginable, while at the same time, the court has not granted relief in other cases with less troublesome facts. In other words, the death penalty is not reserved for the most egregious cases. See Hall v. Florida, where the court granted relief from the death penalty to a man who kidnapped, beat, raped, and murdered a 21-year-old pregnant newlywed, murdering her unborn child, then murdering a sheriff's deputy in the same day. See also Kennedy v. Louisiana, where the court granted relief from the death penalty to a man who raped his 8-year-old stepdaughter so violently that it, quote, separated her cervix from the back of her female part, causing her rectum to protrude into the vaginal structure, and tore her entire perineum from the posterior fourchette to the anus, after which he spent at least an hour and a half attempting to destroy the evidence, all while she was bleeding out. Such disparities can only be described as arbitrary. 105. The timing of when a death sentence is imposed can also lead to arbitrary results. In 2015, then Pennsylvania Governor Tom Wolf granted a moratorium on all executions not already stayed by the courts. 13. It just gives you another website. Where was that? Subsequently, the Pennsylvania Supreme Court unanimously upheld Governor Wolf's moratorium on execution. In 2023, current Pennsylvania Governor Josh Shapiro announced that he is continuing Governor Wolf's moratorium on execution and called upon the General Assembly to repeal the death penalty. 106. The Allegheny County Court of Common Pleas has acknowledged that the moratorium, for the time being, quote, has made it functionally impossible for a jury to impose the death penalty, end quote. In arriving at that conclusion, the court was, quote, compelled to act on behalf of the citizens of Allegheny County who may be called for jury duty to prevent them from undergoing the harrowing ordeal of deciding whether a fellow citizen lives or dies, where the governor's stated refusal to sign a death warrant has effectively removed the decision from the jury. You know what I don't get is the jury is responsible for deciding the death penalty, but that's the only punishment phase that the jury is responsible for. If a defendant is found guilty, that's the jury's job is done. If there's no death penalty on the case, they find him guilty, they leave, and then the judge calls him back for a sentencing hearing, and then the judge hands down the sentence. But for a death penalty case, which is the most serious, punishment, they leave it up to the jury. And I find that weird. I find that very odd. You know what I mean? In other words, a death sentence in Pennsylvania now turns on the whims of the governor and judges, the very definition of arbitrary in a system premised on the unconstitutional right to a jury of one's peers. Well, there you go. That's why. So why aren't they responsible for handing out sentences? Other sentences, like term sentences. That's weird. You could give them guidelines. You could say for this charge, you are only allowed to give them a minimum of this or a maximum of this, and then let them decide, the term. But they don't. The judge hands down terms. That's weird. Between 1978 and 2025, Pennsylvania taxpayers have spent over $350 million on the death penalty, yet only 3 individuals have been executed. In order to execute 3 individuals and overturn the sentences of 209 individuals. Number 15. Just another website. Sorry. Is it that much cheaper? I don't think so. 108. Because I'm telling you, I work in a hospital and prisoners come in we had a prisoner at one point that was a lifer, and he was waiting for a heart transplant. Yeah, we have kids and people that have never committed a crime before in their life, and they're under this guy on the list for as a heart recipient. How fair is that? This guy had his chance, he blew it. Let him die of heart failure, as far as I'm concerned. You know what I mean? A person who's uninsured and broke can't get a heart transplant. Why should this prisoner get a heart transplant on my money? I should be able to decide if he gets a heart transplant. It's my money. It's taxpayers' money that's paying for that. They get the best medical treatment. We do open hearts on tons of prisoners. In fact, I was talking to this one guy. He was in custody, and he said that when he needs a surgery or when he needs dental work done, he goes to jail. He makes it a point of going to jail so that he can get it all taken care of. And then he serves his time or he applies for probation and he's out. These criminals abuse the system just as much as anybody else. They know how to work the system. It's infuriating to listen to them brag about it. He was bragging to me about it. It was crazy. Given the ongoing moratorium, every death sentence received by an individual is effectively a more expensive sentence to life in prison without the possibility of parole. I'd like to see the breakdown on that. In the United States, over 80% of capital cases involve white victims, even though only 50% of murder victims are white. 16, ACLU of Pennsylvania death penalty. Okay. Race plays an inexorable role in Pennsylvania's capital punishment system. Quote, Pennsylvania's death row has one of the highest populations of Black, Indigenous, and people of color in the country at 62%, end quote. Over the past 10 years, Philadelphia has averaged 383.7 homicides per year. Number 17th just gives another website for statistics. In a matter of 37 years, Pennsylvania sentenced 408 individuals to death, and in the last 47 years, Pennsylvania has executed only 3 individuals. Pennsylvania Super Note 15. That means that over the course of 37 years, Pennsylvania has sentenced to death almost the same number of individuals that commit homicides per year in Philadelphia, in just one city in Pennsylvania. Okay, that's not really true, because they're saying that means that over the course of 37 years, Pennsylvania has sentenced to death almost the same number of individuals that commit homicides. You don't know that there's only 408 people that committed homicides just because there was 408 deaths. What if somebody did a drive-by and shot 50 people? That's one person for 50 deaths. So you can't say that. And that's just in just one city in Pennsylvania. There's no doubt that the application of Pennsylvania's capital punishment system is arbitrary and thus violates defendants' rights under the 8th and 14th Amendments to the U.S. Constitution, as well as Article 1, Section 9 of the Pennsylvania Constitution. Roman numeral 3, the death penalty causes excessive delays. 112. The lack of reliability and the arbitrariness of the death penalty inevitably lead to excessive delays that further infringe defendants' constitutional rights. Well, you know what? The crimes that these defendants commit are infringe on their victims' constitutional rights. How about that? So if they're not going to honor somebody else's constitutional rights and they're going to commit these crimes, why should we go out of our way to respect theirs? I mean, if they weren't shitting on the Constitution. Okay? Let's call it like it is. The 8th Amendment applies to death penalty cases with special force because those who face the most severe sanction must have a fair opportunity to show that the Constitution prohibits their execution. Did you give the same to your victim? Did you give them a fair opportunity to protect their constitutional right against an execution before you murdered them? Give as you give. That's how I feel. I'm sorry, but I do. Unfortunately, the procedural guardrails put in place to protect defendants' constitutional rights take time. However, the amount of time in which the justice system takes in implementing these procedural necessities has exponentially increased the already lengthy days in death penalty appeals and sentencing, thus explaining the delay but not mitigating it. Between 2013 and 2025, more than half of the exonerations of death row inmates have taken 25 years or more between the time of conviction and exoneration, 18. But they leave alive, don't they? In 2015, so would you rather it take less time and they don't get exonerated? I mean, because there's progress made in like evidence processing and whatnot. And like before we had DNA testing, the person that committed a murder 40, 50 years ago would not have had the privilege of having DNA profiled. They will now. So yeah, they're going to spend years in jail until something comes up that changes in the treatment of evidence and the processing of evidence. That just goes without saying. That's nobody's fault. In 2015, Justice Breyer detailed the colossal continuing extension of time between conviction and execution or exoneration. I may have to mute real fast because my dogs are starting to act up. The length of the average delay has increased dramatically over the years. In 1960, the average delay because we're having more crime now. So there's more things being tied up in the judicial system. The judicial system is tied up with more cases, active cases. And the exoneration cases take a back seat. I apologize. I don't apologize, but that's just the way it is. In 1960, the average delay between sentencing and execution was 2 years. C. Ahrens, can inordinate delay between a death sentence and execution constitute cruel and unusual punishment? 10 years ago, in 2004, the average delay was about 11 years. By last year, the average had risen to about 18 years. Nearly half of the 3,000 inmates now on death row have been there for more than 15 years, and at present execution rates, it would take more than 75 years to carry out those 3,000 death sentences. Thus, the average person on death row would spend an additional 37 and a half years there before being executed. What do you want? They're doing the best they can, so they say. I cannot find any reasons to believe the trend will soon be reversed. No, it's going to go up. So commit your crime before then, I guess. I don't know. Once the direct appeals process concludes, the death sentence is upheld by the Pennsylvania Supreme Court, and a petition for writ of certiorari, I think, or extension has not been filed. The governor is required to, quote, within 90 days issue a warrant specifying a day for execution, which shall be no later than 60 days after the date the warrant is signed, end quote. As a result of this automatic death warrant statute, Pennsylvania courts have stayed more than 90% of the death warrants, thus continuing to elongate the amount of time an individual spends on death row, wondering if they will ever be executed. You can't have it both ways. You can't say that you don't want them spending all this time on death row waiting to be executed, but ask for a stay of execution, because you know that's only going to study from Marquette University School of Law. Co-victims, families, and friends of murder victims, quote, may prefer the finality of a life sentence and the obscurity into which the defendant will quickly fall, rather than the continued uncertainty and publicity of the death penalty. 20. Death penalty adversely affects families, victims, and defendants. Number 117, with the vast delays in execution and the low probability that an individual will be executed in Pennsylvania, any interest a co-victim may have in retribution can be equally served by a sentence of life in prison without parole. 118. Therefore, due to the extreme delays from conviction to execution, if executed at all, the death penalty fails to serve a penological rationale that cannot be otherwise constitutionally served by life in prison without the possibility of parole. Thus, the death penalty is unconstitutional. F. The court should strike 2 of the aggravating factors identified in the Commonwealth's notice of intent to seek the death penalty. 119. Further emphasizing how defective Pennsylvania's death penalty system has become is the fact that at least 2 of the aggravating factors identified in the Commonwealth's notice of intent to seek the death penalty are factually unsupported and thus should not be allowed to support imposition of the death penalty in this case. I don't know how they're allowed to make such long sentences. It's hard to keep track of what you're reading. Number 120. First, the Commonwealth alleges the defendant has a significant history of felony convictions involving the use or threat of violence to the person. Commonwealth notice of intention to seek the death penalty. There's no dispute that Ms. Virzi has no criminal record whatsoever, and certainly no convictions for crimes involving the use or threat of violence to the person. Yeah, the baby's only 6 weeks old, first of all. To the extent the Commonwealth intends to rely solely on the crimes charged in this case alone as the basis for this aggravating factor, that argument fails. The defense is unaware of any case where the sole basis for the aggravating factor was a crime committed as part of the homicide. That makes sense given that the entire purpose of this factor is to increase the punishment for those who have had repeated and consistent encounters with the criminal justice system. While what is said on the Senate floor may not be relied upon in ascertaining legislative intent, it is interesting to note that members of the Senate, in discussing Section D9, in discussing section prior to enactment of the death penalty statute, spoke in terms of 5 and 10 prior convictions. Here, Ms. Virzi has no such prior convictions. Moreover, a person with no criminal history cannot be said to have a significant history of felony convictions. Second, I agree. I don't think if this is somebody's first offense, I don't think that the death penalty should be on the table. I think that they should be a candidate for life without parole, but I don't think that the death penalty should be on the table. Second, allowing the Commonwealth, especially when you have repeat offenders out there that have never had the death penalty on the table. I don't think that there's any kind of reasoning behind. There's no, it doesn't make sense. Second, allowing the Commonwealth to rely solely on felonies committed in the same course of conduct as the homicide for which the death penalty is sought would render duplicative the aggravating factor at Section 9711 D6, which addresses the situation when defendant committed a killing while in the perpetration of a felony. It is a black letter law that a court should not interpret a statute to render a provision superfluous or duplicative, which is exactly what would occur under the Commonwealth's theory here. Finding that the statutory interpretation that ignores or renders other statutory language superfluous would be contrary to statutory and case law. So they're saying if they're trying to use the murder or the killing of this baby as her aggravating circumstance, but then that's the actual charge. That's the actual act of, is the murder. So how can that be both? Now, if she killed somebody robbing a store, that's the aggravating circumstance is robbing the store with a gun. And to preclude the Commonwealth from proceeding on the aggravating factor that alleged homicide occurred while in the perpetration of a felony. This aggravating factor is of dubious applicability here, where the only other felony at issue is the endangering the welfare of children charge as it relates to LK. essentially the same course of conduct that led to the alleged homicide. I don't know, they may be able to push that, saying that she was committing the felony of child abuse when she killed the child. That's kind of iffy. I don't know. Allowing the Commonwealth to proceed on such a theory would allow prosecutors to seek the death penalty in virtually any case involving a homicide. I thought that first degree murder had to be intent, like premeditated, intentional homicide. And I doubt very much that she intended or premeditated to kill that baby. So I don't know how they're getting away with putting the death penalty on the table anyway. Just a second. Okay. Um, Essentially the same course of conduct that led to the alleged homicide. Okay, allowing the Commonwealth to proceed on such a theory would allow prosecutors to seek the death penalty in virtually any case involving a homicide. They need only charge another lesser included offense like aggravated assault or the like to do so. Because that is inconsistent with the purpose behind the death penalty statute, this aggravating factor should be stricken from the Commonwealth's notice as well. G. Notice under Rule 568. Number 123, Rule 568A of the Pennsylvania Rules of Criminal Procedure requires a defendant to notice the attorney for the Commonwealth of the defendant's intention to offer the defense of insanity or mental infirmity, and also provide notice of defendant's intent to offer expert evidence of mental condition bearing on guilt or punishment, no later than the time frame for filing pretrial motions prescribed by Rule 579 or the court. 124. Pursuant to the mutual agreement of the parties, defendant's notice of defense of insanity or mental infirmity and the defendant's notice of expert evidence of mental condition shall be due 60 days before trial or on or before March 26, 2026. H. Motion to sever the counts relating to AK and have a separate trial for those. 125. Ms. Virzi moves to sever. Yeah. Ms. Virzi moves, so motion to sever the counts relating to AK and have a separate trial for those. AK is the twin. Ms. Virzi moves to sever the counts related to LK, one count each of criminal homicide and endangering the welfare of children, from those related to AK, 3 counts of aggravated assault, and 1 count of endangering the welfare of children. A joint trial of all counts would be confusing and inflammatory to jurors and ultimately would unduly prejudice Ms. Virzi in presenting her defense. Severance of trials is governed by Pennsylvania Rule of Criminal Procedure 583, which provides that the court may order separate trials of offenses or provide other appropriate relief if it appears that any party may be prejudiced by offenses being tried together. Number 127, where the defendant moves to sever offenses not based on the same act or transaction, the court must determine 1, whether the evidence of each of the offenses would be admissible in a separate trial for the other. 2, whether such evidence is capable of separation by the jury so as to avoid danger of confusion, and if the answers to these inquiries are in the affirmative. 3, whether the defendant will be unduly prejudiced by consolidation of offenses. So you have to have an answer, you have to have a yes to 1 and 2, and then you go to 3. For the first element, the evidence at issue must be admissible in a separate trial and cannot be admitted only to, quote, show the defendant's bad character or propensity to commit crime, end quote. As for whether the jury can separate the evidence of the charges, if the charges concern, quote, distinct criminal offenses that are distinguishable in time, space, and the characters involved, a jury is capable of separating the evidence. 1/3. Is such that the trier of fact probably will be unable to distinguish the evidence and apply the law intelligently as to the charges. 2, whether evidence not admissible for one charge probably will be considered for another. notwithstanding admonitory instructions, and 3, whether there are antagonistic defenses. 131. Here, severance is appropriate because each of the elements are met. The evidence of the injuries allegedly caused to AK, giving rise to the aggravated assault charges, would not be admissible in a homicide trial based on the injuries to LK, because the nature, severity, and alleged victim of the injuries all differ. In other words, the evidence of the alleged injuries to AK, scratching, pinching of the skin resulting in abrasions, small cuts, are irrelevant to whether Miss Virzi caused LK's death. Admitting evidence of the injuries to AK would thus be inadmissible in a separate trial for LK, because the former would constitute nothing more than prior bad acts evidence prohibited by Pennsylvania are evidence. Trial court erred in refusing to sever aggravated assault and battery charge from criminal homicide by child abuse, where the defendant's course of conduct toward one sibling, striking on the torso, buttocks, and arms, was distinguishable from the blow to the head that resulted in the death of the other sibling, and thus did not establish a common scheme or plan. This factor thus weighs in favor of severance. Number 132. Second, presenting the evidence related to both AK and LK at the same trial is likely to result in juror confusion. In particular, the events at issue involving both AK and LK are all occurred in approximately the same time frame on the afternoon/evening of June 15, 2024. Moreover, they all occurred at the same location, the Walnut Street apartment. Finally, given AK's and LK's age and the fact that they were infant twins who were almost always together, could also cause the jurors to confuse the two and thus improperly attribute certain actions allegedly aimed at one to the other and vice versa. Finding trial court erred by refusing to grant severance of rape charges against two siblings where, inter alia, there was overlap in the dates of the alleged conduct that might have created confusion, and where the inflammatory nature of the offenses likely added to the prejudice. 133. What they're saying is the jury may find that, well, if she could, kill this one baby, maybe she just didn't have the opportunity to kill the other one. Maybe that's what her intentions were, but she didn't have the opportunity. They can't do that. So that's why they're saying that they need to sever the cases so that she can be judged on each individually. The 133. Third, the risk of prejudice is substantial. It will be difficult for the jurors to separate the severity of LK's injuries from those to AK, and thus it will be nearly impossible for the jurors to not consider the injuries to LK as part of their consideration of whether Ms. Virzi engaged in the conduct related to AK, which is what I just said. Because she hasn't admitted to anything as far as the twin goes. This overlap will prejudice Ms. Virzi by making it more likely that she will be convicted of the conduct related to AK based on the allegations and evidence aimed at the conduct related to LK and vice versa. The court should sever the charges related to conduct directed to LK from the charges related to conduct directed to AK. In doing so, the court should also exclude all evidence and testimony relating to the charges arising out of the alleged conduct towards AK in the trial of LK, and the alleged conduct towards LK in the trial of AK, because said evidence is irrelevant and prejudicial to Ms. Virzi in both circumstances. Roman numeral 1. Motion for individual voir dire. Number 136. Pursuant to Pennsylvania crime publishing or whatever, the individual voir dire method must be used in capital cases unless waived by the defendant. Defendant hereby does not waive her right to conduct an individual voir dire. Number 137. Wherefore, this court must use the individual voir dire method in selecting the jury in Ms. Virzi's trial. J. Motion, that means they're put up on the stand, I believe, right? And questioned by both sides. Pursuant to Pennsylvania, whatever, criminal, what is that? Not policy, but procedure. There is a standard juror information questionnaire that is required to be sent out to potential jurors prior to voir dire. 39. Ms. Virzi requests a supplemental questionnaire be used together with the standard juror information questionnaire in this matter, as provided in Rule 632A1. A criminal defendant's right to an impartial jury is explicitly granted by Article 1, Section 9 of the Pennsylvania Constitution and the Sixth Amendment of the U.S. Constitution, and the jury selection process is crucial to the preservation of that right. 141. This case has garnered both local and national pretrial publicity, which has included many of the alleged facts and photographs of the alleged victims and Ms. Virzi. Additionally, this case includes allegations that could be particularly upsetting and polarizing. It is in the interest of justice, as this is a capital case, and it serves to facilitate and expedite voir dire, which is in line with purpose of juror questionnaires. Prayer for relief. For the reasons set forth above, defendant asks the court to grant all of the relief requested herein. So, I haven't heard whether or not the death penalty is still on the table, but her motion to suppress her statements to the detectives was denied. I do know because I read that the last time, and then it was also included in the article that I read earlier before going over that motion. So, but I don't know about the death penalty or any of that. They didn't mention any of that in the decision. And when I went online to see if the documents were public yet, they were not, from what I found, as far as that goes. Or maybe she just hasn't ruled on it yet, which is also a possibility. She may have only ruled on part of that motion, which was the part to suppress her statement to police. She may not have made a ruling on the rest of it yet. So I will keep an eye out for that, and we will follow this closely. I don't know if Pennsylvania trials, my ear's so red. It's so weird. Look how red that is. I don't know if Pennsylvania trials are streamed, but if it is, we will follow this one because this one's very interesting to me. But yeah. So, it's a pretty sad case. It tugs at your heartstrings, but I want to follow it because I feel like it needs to be made more public. I don't feel like it's gotten very much attention considering it happened in 2024, and I just found out about it, and I'm always looking into cases. So there's that. Let me look real fast. I think, did we have any cases coming up this month? I don't think we did. But let me see. Well, the Wesley Hannard trial is supposed to start on Wednesday. I don't know if I don't think they publicize or they stream their trials in, well, I know they don't in Arkansas because that's where Aaron Spencer's trial is, and it's Judge Elmore's courtroom. So we know how she feels about media being present for her trials. But I will look into that and see what we will cover. We will review day one of the trial after day one is done. Wesley Hannard is the young man, I believe he was 19 at the time. He was arrested and allegedly come on. And he appeared in front of Judge Elmore, who is the same judge
that started the Aaron Spencer case, but she has been since removed. Um, but she let him out on an extremely low bail, just like she did in the Aaron Spencer case. And while Wesley Hernard was out on bail, he reoffended in a different county, and he with two more minor girls, and so he was rearrested. So I believe it's the trial for the first arrest that starts on the 29th. So yeah, she's got a good track record. I have a video going over some of her trial decisions, and yeah, she's not the best, to say the least. I don't know what it is with female judges. I don't know if they feel like they have something to prove or what, but they're either too lenient or they're just raging bitches. In Massachusetts, they're raging bitches. You know, if you look at the first judge in Kelsey Fitzsimmons' case, and then you look at Judge Canoni, I mean, they're just raging bitches. But then you look at Judge Elmore, and she's just too lenient, especially on SA offenders with minors. So pedos and SAs. So I don't know why. Maybe she knows somebody that is in prison for that, and she has empathy for them. I don't know, but she definitely doesn't have empathy for the victims. And that's why Aaron Spencer's in this situation he's in, because he should be given a medal, not put on trial for murder. And doesn't his trial start pretty soon? I don't know. I know Singler has a hearing in May. Why am I not showing Aaron Spencer's trial start date? Oh, because they haven't given us one yet. That's right. Okay, never mind. So, yeah. And then we have the Kalia Toll trial. Starts in June. She's the OnlyFans mom who wanted to go out and have some high school fun because she felt she was owed it. And she left her two babies home alone for 5 or 6 days. It's unclear exactly. And not only were they home alone, but they were left in their cribs, so they weren't able to even try to crawl out or something. And so one passed away, was starved to death, and the other one was close to death when they found him. So she's going on trial starting in June, and I definitely want to follow that one. So yeah, that's all I have for today, and I appreciate you watching this video and spread the word and make people aware of this case. It's becoming far too common as far as I'm concerned. So there's that. But I hope you enjoy the rest of your day. Thank you for spending your morning with me, and until next time, ciao for now.